Hi, everyone. Good morning. Welcome to Caregiver Economics, how to protect yourself while taking care of your loved ones. I'm Stacy Nation. I'm the outreach coordinator for California Estate and Elder Law, and I'm here to present Scott Stewart. He's an attorney that he's the managing partner of our law firm that specializes in estate planning as well as elder law planning. So estate planning being wills and trusts. Elder law planning is how to pay for long-term care and how to, kind of protect yourself rather if you don't die but get very, very sick. What are the options that are available for you? So without further ado, here is Scott.
Thanks. I am quickly looking at an email message that someone sent in here, and I want to make sure I address those issues. And that's going to be regarding home health care for ALS patients and MediCare. So I do want to address that. It's not really part of our program here in terms of talking about caregiver economics because this is a relatively new program, but I'm going to kind of work that through the process so that everybody can kind of be aware of that. It's this one, right, that progresses forward and backwards. So today we're going to talk about caregiver economics, and basically what this means is that we're going to cover a little bit about elder law. We're going to cover a little bit about what the different types of care are, how to pay for that care. We're going to talk about the documents that are critical to enable someone to be empowered to take care of your services. And then finally, we're going to talk about interacting with facilities, how to make all that stuff happen. And then if you have questions, please feel free. I guess they can type them in and we'll be able to respond to them. So someone back there will shout up questions if you're online. So looking at facts, and I know that these facts aren't necessarily super relevant to the folks that we're talking to now, but they are relevant generally in terms of elder law issues as a whole. And that is, over half of the senior population, so if you're 65 years of age, regardless of what your underlying medical condition is, over half of that population is going to require some form of nursing care. In fact, 70% of seniors, regardless of what their diagnosis is, are going to require some form of long-term care assistance. And that, as everyone in the room probably knows, are things like dressing or bathing or feeding yourself or medication management. This does not mean that you are hiring somebody. So that caregiver could be a spouse, it could be a child, it could be anyone who's taking care of your at least one activity of daily living. Now I recognize with ALS the likelihood of needing more than that is substantial, but the simple fact of the matter is that this is a growing problem in our senior population. So if you are the caregiver, if you are the person requiring care, it doesn't change the statistics for you. The most important factor and the most important piece that I have run into, and probably the biggest mistake or missing piece of the puzzle that my clients have, or the people I talk to have, is this statistic. And that is, in spite of the fact that over 70% of the senior population are going to need some form of help, less than 10% have had any form of conversation expressing what those wishes are. Now, that doesn't mean that they've had a meaningful conversation that we're going to talk about here today. That just means someone saying, hey, I want to stay home. No conversation, no discussion about this means that there is no direction or guidance to that caregiver or to your family. And as everyone in this room probably knows, children often don't listen to what we are telling them. And I've got, my kids are 10 and 7, and there's a life lesson I've learned lately, and that is there's a big difference between listening and hearing. I know my kids can hear me, but they usually aren't listening to me. And that's the problem with kids who are caregivers, is that they may hear what we're saying, but they interpret it through their own lens and they don't understand. And then if and when you need more help, you may be in a position where your wishes are not necessarily being fulfilled because those folks don't understand what you want. So that becomes a real problem. And that's that 10% right there. And then here's the Alzheimer's numbers. They're pretty substantial. We don't really care about that here today, but it is still one of the major reasons why people need, nationwide, why people need custodial care. Cost of care, quite expensive. 24-hour in-home care through an in-home care provider, assuming that you are using a licensed, accredited, bonded agency, can exceed $16,000 a month. And the reason why that's the case is that caregivers, when you hire them, are not, critically, they are not 1099 employees. They're not independent contractors. They're W-2 wage earners. So you are responsible for overtime. You're responsible for all the withholdings, whether it's Social Security, FICA, unemployment, all those things. And if you don't do your withholdings because you're hiring someone under the table, they can still come back and nail you. So it's really important that you're aware of that. Nursing home care or assisted living home care, that's averaging between $7,000 and $10,000 a month here in San Diego. So it's rather expensive. And the real problem is that we're dealing with an artificial distinction for most people. And that artificial distinction for most people is that our healthcare system looks at acute care and custodial care very differently. Acute care is, I fell, I broke my hip, I had a heart attack, I had a stroke, I have something that's treatable or curable, and Medicare will come in and help us with that. Now, Medicare is effectively health insurance for people who are over 65, or if you are disabled and been determined to be disabled for a period of 2 years, or you have a condition where it's likely to happen. So most of the folks that are in the room and most folks I'm talking to probably are on Social Security disability and probably have some form of Medicare, likely earlier than 65. Medicare, again, is generally designed to pay for your medical costs, whether that's hospitalization, whether that's the doctors, whether that's the drugs, those kinds of things. It is not generally designed to pay for in-home care. And that's with one really important exception, and that's this. One of you guys sent an article in that I was looking at this morning that talks about this relatively new Medicare program where they've expanded Medicare to help with ALS folks, where you can get a little over 30 hours a month. Now, in my experience, I've never dealt with that program. We just haven't seen it at all. And 34, 35 hours, that's probably the maximum. And even more importantly, it's probably not going to be sufficient to do the work that's necessary. So 35 hours a month of care, when there's 720 hours in a month, really doesn't get it done if you need 24-hour care. So you're still going to be leaning on family and everything else. I suspect that this program will button up really well with other programs that we'll talk about. Because the real issue here is the distinction between acute care and custodial care. Acute care, again, is I fell, I broke my hip, I had a heart attack, I had a stroke, and I need some form of health insurance to pay for the care associated with this treatable and curable condition. Custodial care, on the other hand, is I need help meeting my activities of daily living, dressing, bathing, feeding, medicating myself. If I'm in a dementia world, I need protective supervision because if I'm left home alone, I'm going to get into trouble, that kind of thing. So it's dealing with the day-to-day stuff. The care options realistically fit into 4 basic categories. Lots of folks in the industry like to kind of blur the lines here, and they'll say, we've got 15 different levels of care at our facility. What I'm looking at is really what the building is. I don't really care what the amount or levels of care that exist within the building. What I care about is the structure, because once you're in the structure, you're going to get different things. So in my world, and the way I look at it, we have in-home care. And in-home care means that you are hiring somebody, or there is a family member, someone is helping you in your home. You could own your home, you could be renting your home, it could be an independent living situation where you have people coming in and helping you in your home environment. Then we run into a second category, which can be loosely described as a residential care type environment. Those are more commonly, in my experience, more commonly group style homes, where there's a family that has a home with perhaps 4, 5, 6 different adults that are living in it. The person who owns the home or the staff might have a nurse on staff, and they cater to all of the folks who are living in the home and take care of their needs. Yes, sir.
Would that be what some of these places call themselves, independent living?
No, independent living is more like an apartment because they're not providing any care. You are independent. There may be some type of restaurant or other structure within the building where they will take care of those needs, and you can come down and have meals, and there'll be some type of activities. Independent living is more like a college dormitory, except you can typically bring your own furniture. Residential care is more of a group-style home where someone typically says, we've got to deal with mom or grandma's situation, and good grief, it's expensive, so I know what we're going to do. We're going to get licensed, and we'll bring in 6 other people, and we'll all offset the cost. And there's a lot of those around in doing with that. And if you find the right environment, it can be extremely successful, and it can be much cheaper. Average costs that we've seen over these residential care facilities, $3,000 a month or less. It can be great. But again, it depends upon who's running the house, because it's in some cases they're running very close to the bone, and they'll say, well, you know, it's not really that hot, and we're going to turn the air conditioner way down, right? So they may be cutting corners. So you get what you pay for, and you really need to talk to other folks about that. Yes?
So if I'm in an independent living scenario, I'm looking for in-home care.
Right.
Got it.
Right. So you're looking to bring care in. In-home care, by the way, can get paid through the Medicaid system, and we'll talk about that in a second. Here in California, MediCal. Residential care, which would be, again, those group home settings. Assisted living facilities, those are kind of like independent living facilities, except that they will actually provide some services to you. So very often, memory care facilities are recast as, or their memory care facilities are assisted living facilities that are recast. There may or may not be a nurse on staff. If there is, that's how your medication can be administered. There are very strict laws in California about who can provide and administer medication. And administering medication can be as simple as handing a pill to somebody. If I'm handing medication to someone who's not a family member and I don't have the right licensing and credentials behind me, I can get in trouble, and that's why facilities tend to be very funny about that. Assisted living facilities are not governed under the same code section as, say, skilled nursing facilities, and those are a more clinical environment. Aesthetically, the way those things look is that you walk into an assisted living facility, and it's going to appear more like a hotel. You'll walk in, and again, they'll typically have a restaurant kind of thing, carpeted floors. You have a room with that you can have a lock on the door. You may or may not have a place you can make your own meals, bring your own furniture in, and then they'll say, we will provide some assistance to you over and above that, and then the bathroom will have, pull cords and things like that. Skilled nursing facilities are your traditional nursing homes. So that's a more clinical environment with a nurse's station, beds with rails, maybe shared rooms, although there can be shared rooms in assisted living as well. Typically the floors aren't carpeted because they've got beds with wheels and other things going through it. So kind of a different environment, and it's a different licensing. They can actually administer medications. Doctors typically round there. It's really a much more comprehensive medical situation. So how are we paying for care? Well, in paying for those services when we deal with custodial care, Medicare, again, provides very limited services. Typically, to qualify for any kind of skilled nursing care through Medicare, you have to have been admitted to a hospital for 3 days and 3 nights, and you have to be treating, and that treatment can last as long as 100 days, and they'll pay for nursing home care for that 100-day window. There is now apparently a program that I was looking at earlier that someone had emailed in to me. I'm sure we can send around the link about that article about how Medicare is providing additional services. I will go out and I'll research this and I'll tell you all about that. So that way you can kind of go back and tell the body about all this and close the loop on that. Because if there's 35 hours, that'd be really cool to pick up through the Medicare system. If Medicare is insufficient, and it typically will be if you need 24-hour care or you need custodial care, then you're stuck with your assets and savings, which means you start writing checks. And if you're not Donald Trump or you're not independently wealthy, it's going to get really expensive really quick. And so very often when I'm dealing with clients, they are not only concerned about their needs, but they're also looking at the needs of their children or their spouse or someone else, and kind of balancing all that can be very, very difficult. When I'm often dealing with folks who have long-term care events or needing custodial care, the children, more often than not, try to come forward and help us with those costs. The problem with children doing that is that the care costs are often so high that they don't have sufficient savings to carry them through that, and then they decimate their IRAs, their 401ks, and it creates a problem. Where that communication piece comes in that's really critical is that if you don't want your kids doing that, you need to clearly articulate and say, look, I'm on my own. I recognize that. Don't liquidate your funds. I don't want that financial help. This is not something that you need to bear, because there is going to be that issue. Long-term care insurance? Yes, sir.
So as we're spending our assets and savings, one of the things we've observed people do is get in trouble. They hire private caregivers off of Craigslist or other places.
Right.
We had one caring family who was helping the caregiver.
Right.
Hey, you move in. Oh, yeah, your boyfriend can move in, and we'll offset your pay by room and board.
Right.
No record keeping at all. Any payments made were in cash.
Under the table, right, with no receipt.
So 8 weeks later, the caregiver files Department of Labor. And
big problem. It's a big problem. And that's it, and because you're only liable for 3 times. So that's the problem, and that's why in-home care companies, solve a lot of those problems. Because that person's entitled to overtime. There's an article I just read this week, and I'm not commenting one way or the other, but these overtime rules are particularly insidious. Donald Trump's driver just applied for 25 years worth of overtime for driving him around to all these places. So I don't know how successful he'll be or not, or if that's some political stunt or something like that. But the point is that to the extent that's there, the EEOC and other government agencies are really, really hard on that because they don't want workers exploited. So I would strongly recommend not hiring people under the table, not hiring those folks that way. Have contracts in place, have them be W-2 wage earners, do payroll deductions, do all of those things, because if you don't, you get into big trouble, huge trouble. Long-term care insurance. The problem with long-term care insurance is a special kind of insurance that will pay for care. In addition to long-term care insurance, if you're under 65, disability insurance can be a really good idea as well. For folks who already have a diagnosis, it's going to be too late to do that. Long-term care insurance will pay for long-term care. It's based, you buy a bucket of money. It pays a daily amount that may or may not be sufficient to cover the cost of care. Disability insurance is insurance that replaces your income during a period of disability, and it can replace your income for a period of years or up to the rest of your life. It can be a really good thing. The problem with both of those is that the Obamacare, the healthcare reform laws that eliminated the whole pre-existing condition notion did not apply to those insurances. So if you have a diagnosis of anything that's remotely likely to cause either disability or cause the need for custodial care, whether that's diabetes, a heart attack, certainly dementia, ALS for sure, any of those things, they're going to say you don't qualify. And so that gets us to the last 2 programs, and that's MediCal and a VA program called Aid and Attendance. Let's kind of talk about Aid and Attendance first. Aid and Attendance is a non-service connected improved pension. So it's part of the pension program. VA benefits are some of the best benefits that you can get, and VA benefits typically fall into 2 categories. They're either part of the pension program or they're part of service connection. Service connection is the gold plate standard. If you can prove that the condition that you need help for, or if you were, or any condition was related to your time in service, then you will get a rating and you'll get a check. The most common form of disability for service members is tinnitus, ringing in your ears. You get rated at 10%, and then you get access to medical services through the VA. You get rated more than that, they'll start sending you a check. And what they're looking at from a service connection standpoint is, was your condition caused by or made worse by your time in service? So if you have ALS and you started expressing symptoms during your service, that would be a service-connected disability. I have a really good friend of mine that has Crohn's disease, and he was diagnosed with symptomology similar to that, and he's now rated for Crohn's disease, and the VA picks up all of his healthcare costs associated with that terrible disease. So if you can point that out and say, look, here's what that is, and I was expressing symptomology, and that's what occurred, then you'd be service-connected. So, I'm sure everybody's seen that Stephen Hawking movie, right? So when he was walking and he was stumbling and having those issues, that would be the trigger point. If that happened when he was in the military, then you'd be able to go, right there, that's when it happened. Government, you hold the bag on this, and they'd be responsible for all the care. Now, you'd have to connect all the dots. You'd have to have medical records that made that work, but that's how that would work. Every other program is going to be with the pension program. Pension typically means that you have 20 years in the military. That being said, they have this other program called Aid and Attendance. Aid and Attendance is a non-service connected improved pension. And in order to qualify for it, and by the way, it's tax-free income and access to VA services, which is the formulary and medications and doctors and all the rest of that, you have to prove first that you are 65 years of age or older. You have to prove that you are totally or permanently disabled, or you have to show that you are a patient in a nursing home. You have to show that you have 90 days active duty service, 1 day of which occurred during wartime. Your service does not have to have been actually in combat. So, for example, if you were a Vietnam-era veteran stationed in Berlin while the Vietnam conflict was going on, your dates would line up and you would qualify. There is an asset component and an income component, which we'll talk about in a second. So, under this program, if you are a veteran or the surviving spouse of a veteran, you will get a check. And this really is an income floor. The numbers you see on the screen are the amounts that it's possible that you could receive. So if you are a single veteran with one dependent, you can get up to a little over $2,100 of tax-free income. And so what they're looking at here is that if I was a single, let me just make myself be a single veteran, no dependents. That would mean that I could qualify for up to $1,794. If my income was $1,000 a month and I met all the other criteria, the VA would give me another $794. If my income was, let's say, $2,794, the VA initially would say, I don't qualify for benefits, but if I can prove up that I'm spending, let's say, $2,000 a month on in-home care because I'm paying my child to take care of me, or I've got a professional caregiver, and I've got the receipts to make all that happen, then the VA would come in and say, you've spent $2,000 of your $2,794, so here's another $1,000 of tax-free income to help you along. Your assets have to be probably below about $60,000. The VA, in their infinite wisdom, removed the hard number a few years ago, and they're now looking at your needs based upon actuarial tables. So the idea being that a veteran who's 110 probably needs less in resources than a veteran who's in their 30s. Just the way it is. In terms of dates, if you served during any of these dates, then you will effectively qualify for benefits. Mexican border, World War I, World War II, and your dates have to line up. Remember, you need 90 days active duty service, 1 day of which has to have occurred during wartime. So one of these dates has to have appeared during those criteria. Okay? The other program, I see people giggling in the back. I'm not sure what that's all about. But the other program that we deal with is MediCal. MediCal is a joint federal and state program that will actually pay for in-home care. It will pay for nursing home care, and it will pay for assisted living care. It's a means-tested program, meaning that we have to jump through 3 hoops to get there, and I'll go through those right now. The first is we have to show it's medically necessary. Medically necessary means you're either over 65, blind, or disabled per the SSD rules. So if you meet the criteria of disabled under Social Security disability, and ALS does meet that criteria, you've met the first box. The second question is income. People generally perceive MediCal as a low-income program. It is not. MediCal we're a share of cost state, so if your income is too high, MediCal says that you have to contribute some of your income towards your care costs. The amount of income you've got to contribute to your care costs is going to depend on, number one, whether you are at home or in some type of facility, and then critically, two, whether you are married or single. If you are married and at home, the amount of income that you can keep as of this year is substantially higher than it was, let's say, a year ago, because we just had this extension of this federal law that effectively says that folks that are at home, that are married, the well spouse can opt out of MediCal and keep income of at least $3,000 a month, if not more. There's this really cool rule called spousal impoverishment that says that instead of spouses divorcing to deal with these issues, they can come in and say, I meet the criteria under the family code and under the probate code, and here's my actual expenses, and those actual expenses cause all that income to be exempt. That same rule applies if the ill person goes into a nursing home or assisted living facility, and what will happen in that situation is the person that's at home can say, I need assets and income to maintain my standard of living. So if you have a spouse that's at home that maybe has a mortgage, or there's minor children, or kids in college, or any of these other things, all of those expenditures can all be allocated to that well spouse and divert the resources to that well spouse to meet those expenses, and MediCal will step in and say, we will help. MediCal, generally as a program, will provide for care at home through a program called IHSS. That's up to 283 in-home care hours a month. There's and I believe that will be on top of the Medicare's 35. So that will get you maybe about 50% timeshare at home. There's an IHO waiver, which is, now that I mention it, I probably shouldn't, because there's only a very limited number of slots, and there's about a 2-year waiting list or so to get on that, but that's actually 24-hour in-home care. There's an assisted living waiver where MediCal will pay for care in an assisted living facility. That program also is full. There's about a year waiting list right now for that. There are 40 facilities or so in the county that will pay for assisted living. And then finally, there's nursing home care, and MediCal will pay for about 78 to 80 facilities in San Diego County right now. And that program isn't full. You just have to get into one of those 80 facilities. There aren't any state-run facilities. If you want a comprehensive list of all of the programs that MediCal pays for, I have a book on my webpage. I'll make sure that gets out to you guys. You can download a copy of my book for free, and in the back of it is a comprehensive list that I update 3 times a year with all the facilities, all the services that MediCal will pay for, and you can kind of just look at that list and say, okay, these are all the places, this is what happens with that. The third test for MediCal is assets. The general perception is I can't qualify for MediCal if I have stuff. The problem is that the definition of stuff isn't as broad as what most people think it is. If you're a single individual, MediCal says you can have no more than $2,000 of countable or otherwise non-exempt property. If you're a married couple, they will say that number is maybe $3,000 if your spouse is applying for as well, or a little over $120,000 of non-exempt property. And that number can be moved if you make a showing that the spouse that's at home, the well spouse, needs resources to support themselves or other dependents. Critical word, non-exempt. Things that are exempt that do not impact eligibility: IRAs, 401ks, 403bs that are in a payment status. Business property. So if you own a business and that all the property associated with that business is exempt. Rental property can be exempt. Your home is certainly exempt. Your car is exempt. Annuities can be exempt. Some life insurance can be exempt. But the big ones are really the IRA, the 401k. Those assets do not impact eligibility for MediCal as long as as long as we disclose them to the state and as long as they meet the criteria. For IRAs, 401ks, and 403bs, that just means that we're receiving income out of them, no matter how small that income is. And they'll look at that and say, that $1 million IRA that you're taking the income distribution on, we don't look at that at all. It doesn't count. We don't care. So MediCal, again, pays for custodial care. The VA is a tax-free income stream. And then we've got that really cool new Medicare program. Documents. It is critical that you have some, if not all, of these documents. Many of these documents will cost nothing to do. They are free. The problem with these documents is that they can only be created by you if you are still lucid and competent. If you lose your ability to communicate, or you're perceived as no longer lucid or competent because, let's say, you've got dementia or some other situation going on, then we can't design these documents. What drives me crazy is I often have family members come in and they'll say, my dad was diagnosed with Alzheimer's disease 10 years ago, for example, and now the bank won't let him sign his checks. I need to get a power of attorney. And I'll say, well, I can't do that. Or worse, they'll say, well, okay, we can write a power of attorney. I got to meet him. And then they'll look at me and say, well, he doesn't know who anybody is anymore, and he can't even communicate. And I have to look at them and say, well, I can't help you. If you don't have the documents that are up on the screen, then that means that you are opening the door to what's called a conservatorship. You want to avoid conservatorships like the plague. A conservatorship is where the court comes in and says, we have a person who cannot meet their needs. They do not have many of these documents, and I'll go over them in a second, and therefore we are going to appoint someone to manage that person's affairs. The problem with conservatorships is that they are extremely expensive. You're looking at, easily between $40,000 and $100,000 in attorney's fees to get that done in the first year. And the reason why is that you have these multiple trials. Now, if everybody walks in and stipulates to everything and you get everything through, you might be able to get it done for 40 or less. And the reason why that's the case is that in a conservatorship setting, all the lawyers in the room, and there will be at least 2, if not 3 lawyers in the room, all get paid for by you. And the judge is going to be very, very cautious about stripping away that individual's rights. So they're going to look at this individual and say, is there a least intrusive way to do this? And when they're going through that process, the court is going to take a very, very well-reasoned approach to doing that. And what I mean by that is that if anybody brings up any objection or anybody brings up any concerns, or if the court on its own motion brings up any objections, the court is going to say, okay, all the lawyers that are in the room that are working on this, go home, work on this, brief this issue, bring it all back to me in another month or so, and then we'll readdress that issue. And when you say, and I've done this before, I've been in court and I've said, Your Honor, my client really can't afford all this stuff, and I've literally had judges tell me, Counselor, it's only money. And I'm walking out the door kind of flabbergasted saying, yes, but that's the lifeblood of what my client needs to maintain whatever the quality of life is that they're doing. So not having these documents really can put you in harm's way. The first document, by the way, the first document is a free document, and the most important document of all of them, in my opinion, is your Advanced Healthcare Directive. California's created a statutory form. You can go to Google and you can Google California Statutory Power of Attorney and download it, print it up. It just needs 2 witnesses. This is the document that people generally perceive is a document that says, and they perceive that the only thing that it does is it directs someone to either withhold care or not withhold care. That's not the only thing that a healthcare directive does. What a healthcare directive actually does is it says, I am empowering this person to manage all of my healthcare decisions if I'm in a condition where I cannot self-direct. That's what the form does. If you leave the section in the middle about choice to prolong life or not to prolong life blank, I'm not advocating that you do that, but if you leave that section blank, the form will still do 90% of what it's designed to do. So, for example, if I were to leave here today, get into a car accident, have a head injury, and be unconscious, my wife of 15 years is not automatically my health care surrogate. There is no default in California. So if there is a fight between her and my parents, and there probably would be, the court would say, go get a conservatorship. The hospital would say, go get a conservatorship and spend all of that money to determine who's in charge of making my medical decisions. Healthcare directives cost nothing to do. They are the most important document because that's the document that is going to say, this is the person who can go to the pharmacy, manage my medications, interface with my doctor, talk with them about my treatment plan, deal with all those issues. Within this document, you do not want to name multiple agents. You want to have it be a hierarchy. So one person's in charge. Maybe it's your spouse. Maybe it's your adult child. Pick your favorite one. Then your next favorite, and then your next favorite. Whatever it's going to be, have your hierarchy of agents, have one person in charge. The HIPAA waiver, the second document up here, doesn't give anyone authority to make decisions. What it does is it gives people access to your medical information. So you could have your healthcare directive say, I want my wife to be first, I want my mom to be second, I want my dad to be third, and I want my brother to be fourth. What that means is that my parents and my brother would have to go to my wife to get my medical information. If I have a HIPAA waiver, then what that will allow is that they would be able to go directly to the physicians, directly to all those folks and say, what's going on with Scott? Why, what's going on with that? And it's an independent check to make sure that, that those recommendations are actually being implemented by my agent. I find that it significantly reduces tensions in families because people are usually very, very curious about what's going on. And then when they're curious about what's going on, that causes them to begin to lack, stop trusting the person who's in charge of all that stuff because they feel that that person isn't being responsive enough or whatever. The person who's often in charge is then looking at the family and going, well, they don't believe me. Why don't they believe me? So it creates that conflict. The HIPAA waiver, I find, actually reduces conflict because everyone has the ability, everyone that you pre-approve has the ability to access that information directly. Financial durable power of attorney. What that document does is it says, this person is in charge of my assets. If you have a trust, this person will be in charge of anything outside of your trust. Those assets are commonly things like IRAs, 401ks, 403bs. Those are generally not trust assets. Neither is most life insurance and annuities. All those have beneficiary designations, so those are more often than not put into your trust. Those assets would be managed through a power of attorney. Again, we want to have that same hierarchy of agents because if you say, I want my mom, my dad, and my brother all on that power of attorney, then that means all three of them would have to sign the check or consent to the the payment or to the healthcare decision if we're dealing with a healthcare directive. And if all three don't consent, then you don't get your situation solved. They basically will say we won't support that or we won't help you with that, and you're kind of on your own. Because it takes all three folks. It takes unanimous consent. Or creates the same problem because if one person withholds consent, they have the ability to stop payment on the check. The durable power of attorney also allows for the management of any services or creditors that you have. So if you think about, even if you have a trust, if you think about your SDG&E bill, for example, or your cable bill or your credit card bills, those are generally not in the name of your trust. They're in your name individually, and that power of attorney allows that person to interface with those entities. A will. A will doesn't do anything for you while you're alive. All that it does is says, upon my passing, distribute my stuff to these folks. You have to go through probate. So if I were to die and all my stuff were to go through probate, with a will or without a will, it would take 2 years for my wife to get my stuff, because that's how long it takes to run a probate right now. If I don't have a will and I don't designate how I want my stuff to be given, the state has a system in place where they will determine how your stuff is going to go. The state has no interest in taking your things. What the state will do is the state will say, you're going through the intestacy statute. So in my case, if I were to die today without a will, my wife of 15 years would take 1/3 of my estate. My children, who are 10 and 7, will take the remaining 2/3. And that's not because that's what I want. That's because that's what the intestacy statute says. If I don't want that to happen, I need to have a different plan that says, do it this way. So if I want all my money to go to the ALS Society, I can say, I give it all to that through the will, and that's what will happen. On the other hand, if I say I want it all to go to my wife, then that would happen too, and my kids would not be automatic takers. For larger estates, or people who own property outside of California, that's where people generally create trusts. Here in California, a large estate is defined as an estate in excess of $150,000 gross, not net of expenses or creditors. So if you own a home that's worth $1 million with zero equity because you have a $1 million loan against it, that home will be regarded as a $1 million asset, and it will be considered a large estate, even though it's worth nothing. Trusts don't go through probate, but they do go through a similar informal probate process, and they allow for a third party to manage your stuff while you're alive, and they also allow for the distribution of your property at your passing. They don't go through probate, so it's a much faster process to get resources to either a spouse or children or someone else. It's very simple. In my opinion, I believe that of the 5 documents, again, I think the healthcare directive, which again is free, is the most important one, because that's the document that will govern what you want to have happen. When you are dealing with these documents, it is absolutely critical that you document what it is that you want to have happen in these documents. Yeah.
So we've got a question coming in online. They're essentially asking, okay, I went to LegalZoom and I did my will.
Right.
How do I make it official or take it to the court or somehow take it to the next level?
Okay, so there is no document repository for any of these documents. Documents that are created are presumptively valid. There isn't someone who's going to go out there and say, that LegalZoom document fails because of whatever. That is until you actually try to implement it. So in looking at this, the healthcare directive doesn't need to be notarized. That's a 2-witness document. The HIPAA waiver, power of attorney, and trust all need to be notarized. A will needs 2 witnesses. As long as those witnesses are self-proving, meaning there's magic language in there in which they swear that they've seen you, that they saw you sign the document and other stuff, then those witnesses won't have to come to court and say, I actually saw it happen. So you want the self-proving language. But as long as it meets the minimum criteria, it's going to work. LegalZoom documents can be great. Susie Orman documents can be great. My experience with them is that they're often better than what's designed by my brethren here in town, I'm kind of ashamed to say. The problem, though, with legal documents and all these documents generally is that there's no standardized form. There's a standard form for healthcare directives because it's a statutory form. There's a statutory power of attorney, which is terrible because it doesn't define its terms, but there really isn't a standardized form here. And so with most things in life that are relatively complicated, in which there's experts that help you with this stuff, what they're looking for, and what I'm looking for, is to have a dialogue with my clients and to ask questions. And those questions are designed to provoke a response, because what I'm doing is actually testing what will happen. So a while ago, I read an estate plan that was on the one hand, one of the best estate plans I've ever read in my life, and on the other hand, one of the worst estate plans I've ever read in my life. And the reason why that's the case is that this gentleman, who was very, very controlling, had hired this attorney who wrote this absolutely brilliant estate plan. Took it home, read it over after he'd signed it, took out his Sharpie marker, and never interlineate your documents, by the way, but took out his Sharpie marker and started editing his document. And when he started editing his document, he was taking out stuff that was in it that was going to be highly relevant, such as, if one of my children died, did I want their portion to go to my grandchildren? Or if someone was disabled, did I want it to go into a special needs trust? And took out all the tax language, so there's going to be negative tax consequences. Because you looked at this and said, I don't understand what this stuff means. So what lawyers bring to the party is they ask pointed questions, and then those pointed questions generate responses and test whether or not your document is going to respond the way you want it to, with various contingencies. And that becomes really critical. Without that, then you start running into an issue. So again, your documents need to be reflective of your intentions. They need to spell out what you want. And then even more importantly, they need to they need to make sure that they're reflective of your intent, and give a clear path. You have some path that you've designed. If that path is tied up in your head and you cannot communicate that path, whoever follows then has to create a brand new path that may or may not be reflective of your own. It's like recreating the wheel, right? It's better to say, here's my wheel that I want, as opposed to, I don't know what wheel he wants, so this is the path of least resistance, I'm going to do something else. So when looking at this stuff in families, it's critical that we actually do have these conversations about what we want. Don't make it depressing. Make it happen. Understand how facilities get paid to get into there. I'm not sure what this marketing with real estate agents is about, other than the fact that real estate agents, they're going to get paid a commission from your home. But you do want to have the ability to communicate what it is that you want. Document what you want, spell it out, write it out, and put it down. When I'm dealing with clients, or I'm dealing with the court in cases where it is unclear or there's contentious families that are fighting over issues, more often than not, what I like to be able to do is reach into my briefcase and pull out a statement from my client when they still were capable, saying, funny thing, Your Honor, everybody's fighting about what my client wants, and we've got written direction right here as to what it is, and we're down here on step 12, but clearly in step 12 he wants this to have happen, and it's a reasonable request. And if it makes sense, the court is more inclined to go with what the disabled person wants, rather than having some court-appointed attorney or social worker or someone else impose a plan on you, as long as it works. Those plans need to consider the cost of care, locations of care, and what's reasonable. If your care plan is, I want to stay home by any means necessary, that is not a defensible plan. It just isn't. I'm not going to be able to go into court and say, Your Honor, I know that there's no food in the refrigerator and the place hasn't been cleaned in a year, and it's a fire hazard and it's been condemned, but he wants to stay home by any means necessary. I'm going to get laughed out of the court. It's not going to work. But if we walk in and say, you know what, I want to stay home as long as I can afford it, and this is the caregiving, and here's the resources, and here's my plan to make that happen, whether it's sell the house, reverse mortgage, liquidate the IRAs, the annuities, my spouse is going to work, whatever, my kids are going to help, whatever it is, having all that laid out then gives a position where we can walk in and be able to push back on adult protective services or other entities that may be trying to come in and remove you from that environment. So in summary, what is it that you need to do? One, you need to make sure that your estate plan is reflective of your intentions, it's updated, it has the right agents in place, the agents know where those documents are, and they're ready, willing, and able to step up and do that. And critically, those documents reflect your intentions, your morals, your beliefs, and the outcome you want. And that includes where you're going to get care, how to pay for it. Two, you need to be familiar with the different levels of care because in all likelihood, statistically speaking, placement is inevitable for a significant percentage of seniors. And if you are a caregiver for someone who needs help, very often caregivers wind up needing custodial care help because they have stress-related injuries. They may be attempting to move someone and they get injured. So having a plan that understands the different levels of care and contingencies, if my caregiver gets taken out, my spouse gets taken out, who's going to step in and help with that, can become extremely helpful. So levels and locations of care. And then three, having that care plan that says, again, my wife is taking care of me, she no longer is willing to do so or no longer capable of doing so. What am I going to do? Am I going to move into a different facility? Am I going to start hiring caregivers? Is a child going to come in and help? Have that plan laid out so that in the event that the wheels fall off, someone can literally step in, pick up your playbook, and start running your plays and have the outcome you want. If that isn't clearly laid out and there isn't, with the documentation, there isn't a clear hierarchy of power where things can be passed through and have the next person step in into the shoes, then that's where you run into the problem. That's where you wind up going to court. That's where the whole system kind of breaks down and you wind up perhaps not getting the outcome that you want. So communication really is key. Documentation is key. So I want to thank everybody who's online. Yes, sir.
So can we go back to advanced medical directives?
Sure.
In your example, you left here today, got hit by a car. You didn't have advanced medical directives, so your wife cannot dictate. So while you're spending $40,000 to $100,000 setting up a conservatorship, what's happening to you in the hospital?
So let's kind of talk that through.
Okay.
Under California law, there is no default. That being said, more often than not, in that situation, the hospital is going to look to someone who has apparent authority. So if my wife walked in the hospital, and she was the only person who walked in, and she said, "Oh yeah, I'm his agent, I'll bring you that document 2 weeks from never," and her wishes or her desires were consistent with what the facility thought my wishes were or thought that were in my best interest, they're probably not going to investigate beyond that. So that's not legal, it's not right, it doesn't mean it's the appropriate way to do things, but they're not going to go beyond that. If my wife walks in with my brother, my parents, and everybody else, and they all, as a group, agree on that care plan, again, the hospital is probably not going to give me any pushback, and they're going to let it all run through. Where the problem lies is that as soon as there's any conflict, my brother shows up and says, "I disagree with that treatment plan. I disagree with this," then the hospital is going to come back and say, "Uh-oh, who's actually in charge here? I need to see the documents." And when they want to see the documents and you can't produce them, they're going to say, "Go off to court."
And you're laying in bed.
And you're lying in bed and you can't communicate your wishes. So my feeling is that although in all likelihood, for the vast majority of folks, they're not going to run into a conflict because everybody's going to come together and say, this is okay. Although, think about Terry Schiavo for a second. Terry Schiavo, the case in Florida. Big difference between what the husband wanted and what the parents wanted, and that went all the way to the Supreme Court and back because she didn't have a health care directive. My point on this stuff is, could you get by in all likelihood without the document? Yeah, probably. It's probably a coin flip. But is it worth the risk for a document that costs exactly how much to do? Right? Do you have to see a lawyer to have a health care directive designed? No. Are you going to pay anybody? Well, I guess you're paying something. You're going to have 5 sheets of paper and whatever the ink is, right? So there's some sunk, well, unless you go to the doctor and they'll give you one for free. But so there's, and then I guess you got the gasoline to drive there. But there's some sunk cost in that, but it's nominal. And it eliminates the possibility of any problem. And then even more importantly, it eliminates the fact that you might have the bad seed person who shows up and says, I'm in charge. In a completely different context, before we had, in the same-sex marriage context, so before we had same-sex marriage and the like, one of the biggest problems was you had the long-term spouse who had no rights to manage the care of their spouse who was in trouble, and the family that was often very much at a remove would show up and then box that person who's been the primary caregiver and support touchstone for that person for decades, be removed from the equation. So these documents really are designed to deal with that situation. So again, I'm not saying everybody's going to have conflict, but I am saying that as a lawyer, I tend to see more conflict than maybe other folks. And a free 5-page document that can resolve this major issue, why not?
And you stressed sharing it with your loved ones and families, so there's no surprises.
I think that in a situation with ALS folks, I think you should. I think you should make, in fact, you probably need to lodge it with your doctor so they know where it is. With my younger clients, I'm not as that doesn't kind of motivate me to have the documents go out, because very often my clients are struggling to maintain control, or they have complete control and they're like, you know what, I don't want my kids to know about my my foot problems, right? So my bunions are my business, right? Stay out of my affairs. But they want, in the event that there's a problem, they want someone to be able to swoop in and solve that problem. So that's where it would be. The book, by the way, if you go to estate-elderlaw.com, on the first page there's a link that says long-term care planning. You can click on that link, and the book's a free download. And you'll have to give us your email address because it's too big to be sent. I don't. The IT guys have got that set up. But the long story short is you can get the book for free by going to my webpage. Any other questions? Well, thanks again for having me out. I wish everyone well, and I appreciate having the opportunity to talk to you guys.
Thank you for coming. We really appreciate it. Again, this has been recorded, so it'll be on our YouTube channel, and we'll add the links to the documents and the book download. So that concludes our Care Services meeting, and thank you to Life Pro Financial Services for hosting our event.